Awesome. It's 12. I think we can start. So why don't we kick off? Thank you everyone for joining our next So Now You Know webinar series. In this series, I will be taking you through online do's and don'ts and cybercrimes to be aware of. These are things that I'd like to draw to people's attention and just to let you know of in your day-to-day, everyday life. So let's kick off. To introduce myself, my name is Lauren. I am a data and commercial lawyer here at Legalese, and I'll be taking you through this webinar today. Before we kick off, I want to list the talking points that I will be going through in this webinar and what I'll be chatting to you about. First off, I'm going to tackle commenting online and negative speech online. Then we'll be chatting about the Cybercrimes Act and all the crimes that will be considered cybercrimes under the Act. Then we'll be discussing marketing messages and spam emails, social media and posting online, and then finally, online shopping and the Consumer Protection Act. Before we start, I'd like to say welcome to the internet. I'm going to be your guide. We're going to be chatting briefly about things, and at the end, by all means, feel free to ask me any questions that you might have. To kick off, I thought I would just discuss briefly the legislative background to the internet laws and the things that I'll be discussing. I'm not going to do a deep dive into the law, but just to give you an idea of where the information that I'm talking about stems from. As I said, the internet is not as lawless as it may seem, and with the development and the dawn of further legislation, the internet in South Africa is now more regulated than it ever was before. As I said a bit earlier, the aim of the webinar is not for me to retell you the law or what the legislation says, but to give you a practical and everyday understanding on the law and how it regulates our conduct as individuals and our internet usage on a day-to-day basis. Whether it be scrolling through social media, shopping online, reading blogs, reading articles, I hope to break down and, excuse the pun, the legalese, and to provide you with a simple view on cybercrimes to look out for and conduct to avoid online. As a brief background, in South Africa, our online activity is regulated by a few pieces of legislation. This legislation includes the Cybercrimes Act, the Protection of Personal Information Act, which you've all come to know, which is POPI, the Electronic Communications and Transactions Act, this is ICTA. This regulates, or is actually the first starting piece of internet legislation, and it regulates lots of things, for example, internet signatures and all sorts of communications and e-commerce online. We have the Films and Publications Act, which, as the title states, regulates films and publications in South Africa and has been updated to regulate the distribution of films and publications online, which includes streaming. And then finally, the Consumer Protection Act, which regulates e-commerce and online sales generally. Cool. Our first point, commenting online and hateful online speech. Commenting online. We've done it, we've seen it, and we've experienced it. Everybody knows the comment section. The comment section has taken over the internet as we know it, and is actually more popular than whatever is posted above it. There are reality TV shows which center around what the comment section says, but what seems to be lost in the process of fighting wars via keyboard is that our words have consequences. And what are these consequences? Defamation. We all know the term defamation. We've heard it before, we've probably said it. We understand the basics of it and the fact that we understand that someone cannot defame our character or our dignity or things like that, but do we understand what this means in respect of commenting online? So although we have the right to freedom of speech and you have the right to comment things and say things, especially on social media, someone also has the right, and where they feel that they have been defamed, they have the right to approach a court and to lodge a claim. Defamation is, however, not prescribed in legislation, and it's based in the common law, which is the law that's passed down in our courts and through our case law. So defamation has the 4 requirements which you'll see listed here. These requirements need to be proven in order to prove that there has been a claim of defamation and to be successful. The first aspect is that the comment or defaming comments must have been published. In respect of social media, it's clear that this is ordinarily met off the bat. If you've posted a comment to Facebook, you've posted a comment to Twitter, to Reddit, to YouTube, to wherever the case may be, it's normally deemed that it's published. The next two aspects, which are that the comment was wrongful and that it was made intentionally, will be proven and normally established when it's proven that the comment is published. However, it is up to the person who made the comment, and in this case, the defamer, to raise a defense to prove that they've not, in fact, defamed someone, and and there are certain defenses under law which that person can raise. So I'm not going to get into those specificities, but I just want to state that although getting to court is not cheap by any means, I just want people to understand that it is a possibility. And defaming doesn't necessarily mean defaming a person. You can also defame a company or their brand because they have a right to protect their brand. And you never want to end up in that kind of hot water where you might be defaming anyone or specifically a brand, or might be heading to court. Court is costly and expensive and always best to avoid. The Cybercrimes Act. This is where we move into the realm of malicious communications, which is what it's known as the Cybercrimes Act, which is hateful online speech. So under the Cybercrimes Act, it is a crime to send a data message to a person or a group of persons, or even the general public. So again, the comment section, with the intention to incite the causing of damage or to property or belongings, or violence against a person or group of persons. So inciting any sort of riot or hateful action. And although it may seem far-fetched, like who would do that, who's going to sit on the internet and incite a riot, you'd be surprised how quickly one frustration turns into something a lot more chaotic and sinister when you have hundreds of people who are throwing gas onto an uncontrollable fire. An example of how things escalated to the point of a riot and violence was the riots that happened in KwaZulu-Natal last year. That was a case of like negative speech being perpetuated online and inciting a riot and causing a riot, which in turn turned into a massive thing that stretched across provinces. So although it may seem far-fetched that you may intentionally start a riot online, one frustrated comment leads to two, leads to three, leads to mass. And then the Films and Publications Act. So the Films and Publications Act was recently amended to sort of update the act in line with current law and current times and the use of the internet as well, because the Films and Publications Act was initially published in the 90s, and it kind of related to how things worked back then, but it's now been updated to how things operate now. One of the updates that was included in the Films and Publications Act is that it allows members of the public to complain or lodge complaints to the Film and Publications Board, the FPB, about unclassified prohibited content or potential prohibited content. Prohibited content is content that includes propaganda for war, incitement of imminent violence, and the advocacy of hatred. Very similar to what is mentioned previously under the Cybercrimes Act. And this includes these prohibited content is in relation to the services being offered by any person and includes a distributor. So under the Films and Publications Act, they use the term distributor. This can either be commercial or non-commercial. And a distributor is someone who conducts the business of distributing films, games, or publications, whether commercially or non-commercially. So whether for profit gain or for not. In terms of the Films and Publications Act, where the Films and Publication Board establishes that there is merit to a complaint, or that the content in fact amounts to prohibited content, or that it has not been classified, meaning that the Films and Publications Board has not provided it a rating. This can be the over 18, under 16, PG-13, etc. The FPB are entitled to issue a takedown notice, which is in effect a notice to force someone to remove that content in terms of the Electronic Transactions and Communications and Transactions Act, to a non-commercial online distributor, or in fact an internet service provider. This has far-reaching consequences in the sense that under the Films and Publications Act, an internet service provider is compelled, essentially, that they must give information to the Films and Publications Board or the South African Police Services on the identity of the person who published that content. Meaning, whatever internet service provider you use, there are lots in South Africa, they'll get issued a notice where they are forced to provide your name to the police or to the Films and Publications Board to confirm that you're the one that posted this content. Initially, when the Forms of Publications Act or Amendment Act was released, this day's concern that this effectively allows the Forms of Publications Board online censorship. They have this all-encompassing power to decide whether content amounts to propaganda for war, incitement of violence, and advocacy of hatred. And the reason why this is an issue, because these are things that are ordinarily decided by a court, by judges, and not necessarily by the Forms and Publications Board under the Forms and Publications Act, which ordinarily wouldn't regulate something like this. But this is fairly new and it hasn't yet been discussed in court, but the talk is that this will be something that will have to be decided by the Constitutional Court. Cannot be said now how this is going to work, and we'll have to see how this online censorship is going to be regulated in our country. But it's definitely novel, and it will be interesting to see how this is done. The Cybercrimes Act. So the Cybercrimes Act is a fairly new act. It was actually, so the act was assented to in 2019 or 2020, if I believe, but most of the sections only came into operation on the 1st of December 2021. The sections that came into operation include Chapter 1 of the Act, which relates to cybercrimes, malicious communications, which is what I had mentioned previously, and for a mouthful, the attempting, conspiring, aiding, abetting, inducing, inciting, instigating, instructing, commanding, and the procuring to commit an offense. In other words, helping someone else to do a cybercrime. These are all the sections that came into operation. Without getting into too much detail, I want to mention what these cybercrimes are and which ones have come into operation. Firstly, the unlawful and intentional access of a computer system, computer storage system, or the interception of data. And this is what we've come to know as hacking. Hacking is now officially a crime under South African law, and it is offense under the Cybercrimes Act. Secondly, the unlawful interference with data or computer program or a computer data storage medium or computer system. So interference under the Cybercrimes Act with a computer system or medium or storage system means to alter data or render the data vulnerable or damage or deteriorate data in a computer program or storage system. So this means to go online or to go onto someone's computer and damage their data, interfere with their data. If data has been stored on systems, cloud systems, it's to interfere with that storage system or any system like that. It's very similar in relation to hacking, and the two are sort of interrelated. Next is the unlawful acquisition, possession, provision, deceit, or use of anyone's password, access codes, or similar data device. We've understand this to always have been a crime, but it's now officially recognized that you cannot access or take unlawfully someone's password, their access code, or anything similar to that. Those are personal and should not be accessed. Next, we have cyber fraud, cyber forgery and acting, and cyber extortion. These three things are all traditionally crimes under the common law, but in progression to understand today's day and age, they're now being accepted as cyber crimes and accepted as being cyber crimes under the law. Cyber fraud, it's ordinary fraud as we understand it, but simply perpetrated over the internet or over a computer system. Similarly, cyber forgery is the unlawful or the intentional defrauding by making or creating false data or a false computer program. Then cyber uttering is where you pass off or use the false data or false computer program which was created fraudulently in order to defraud someone. So whether or not you create a computer program to defraud someone, it's still a crime under the law. And then cyber extortion is, as it means, extortion over the internet or over a computer system. Another crime which is being accepted now is theft of incorporeal property. This might seem a bit interesting, and to explain, incorporeal property is anything that is intangible, cannot be physically held. So this is importantly property such as intellectual property. So it is now a fully recognized crime to steal someone's intellectual property, including their trademarks, their copyrights, their brands, their designs, anything that is intellectual property or created by someone. It is now a recognized crime to steal such intellectual property. And lastly, as mentioned a bit earlier, is sending a data message which threatens or incites damage to property or violence or discloses an intimate image is a crime. I will discuss a bit later on in the webinar the sharing of an intimate image, which is come to be known as Territorial. Under the Cybercrimes Act, a lot of these cybercrimes are in fact crimes and they are prosecutable in a court of law. However, what the Cybercrimes Act has added is that in instances where someone has laid a charge against another person for a malicious communication, so that is an email, data message, comment, etc., that incites any violence against that person or is threaten the safety of that person is allowed to apply for a protection order pending the finalization of the case. The purpose of the protection order is to prohibit that person from disclosing or further disclosing any data messages which relates to the charge. So to stop the person from continuing to post that malicious communications, or to have a service provider, so whether it be an internet service provider or an electronic communication service provider, to host or disclose that data message which relates to that charge, or to remove or disable the person's access to that data message, so as to protect the person from the violence or the threat of violence against them. The last thing that the Cybercrimes Act has introduced is extraterritorial jurisdiction of the court. So South African courts under the Cybercrimes Act have extraterritorial jurisdiction, meaning that they are able to try any cybercrime which is committed outside of South Africa if that cybercrime was against or affects any person, public body, or business which resides or is incorporated in South Africa, or a restricted computer system within South Africa. So this means that regardless of where crime was committed, if it was committed against a person in South Africa, then the crime can be tried in the South African court. Although this power is great, and it's great to think that South African courts now have the ability to try cyber crimes like this, whether the courts will track down an online perpetrator remains to be seen, and it's definitely something that we've watched on Netflix. You know, Netflix documentaries, I don't know if you've seen them, but it will remain to be seen how this is applied and how these perpetrators are tracked down. But it's definitely comforting to know that if they are caught, they can be tried here. So next, marketing messages and spam emails. We all know that graveyard section of our emails where marketing emails go to die. You more than likely have at least 20 SMSs which are purely marketing and are awaiting the death of deletion. But how legal are these messages? Well, it all depends on if you are a customer or not. So where you are a customer of the person that's marketing to you or the body that's marketing to you, your contact details must have been obtained in the context of a sale of a product or service. So what this means is that when you're trying to buy something online or buy something in the store, where you accept someone's privacy policy and terms and conditions, and they've taken your information in this manner, they are allowed to market to you. The next requirement is that any sort of direct marketing, whether it be through email or SMS, etc., can only relate to that marketer's own or similar products or services. So if you've signed up to purchase a candle from a website, that candle maker can only market to you therefore the products that they make themselves. They cannot market someone else's products or anything in addition. Lastly, and most importantly, you must always be given the right to opt out at the time that your information is collected and at each and every time that a communication is sent. It is therefore unlawful for a marketer to send you any email or any SMS that doesn't allow you to opt out or unsubscribe. If you think about it in the context of SMSs, that is the provision at the end of the SMS. You'll see that says stop, SMS stop to opt out, or stop equals opt out. That must be there. It is unlawful for that not to be there. And especially at the end of emails, at the very end of the email, there should be a clear option for you to click, for you to unsubscribe. In circumstances where you are not a customer of the marketer, this is called direct marketing. And this is well regulated in terms of POPI. It is something that POPI was enacted to address, if we want to recall, many years ago, not that many. It was a big problem in South Africa with direct marketing and customers receiving phone calls all day for products from brands or companies that we didn't even sign up for. So now under POPI, where you are not a customer of the marketer has one chance to obtain your consent, and it must be done immediately. And if you deny your consent, it's completely refused, and they are not allowed to market to you again. So yes, you can still receive that marketing call because your information may be contained on a specific database, but your consent must be requested in order for them to market to you. And if you refuse your consent is refused permanently, and you need to be removed from that person's database and not marketed to again. It is unlawful to perpetrate direct marketing where consent has been denied. Next, social media and posting. Social media is an important thing, and I find that people are very uncertain as to what to do in a lot of circumstances with surrounding social media. What do you do if you've been catfished? What do you do if your copyright has been infringed? What do you do if you've been online bullied? And I cannot emphasize this enough. Terms and conditions, terms, conditions, terms and conditions. Social media companies such as Facebook, Twitter, or YouTube, these are massive multinational companies. The platforms that they operate are updated and developed to ensure that they offer the best user experience possible, as they are responsible for managing the community of users on their platform. These social platforms are responsible for everything that happens within their platform, and they are in fact actually always the first point of call when you have any sort of grievance. Most popular social platforms, and this spreads across from YouTube to Tinder, have built-in dispute resolution processes and step-by-step guides on how to handle any situation faced on the platform. Because chances are this has happened before, and they've had to deal with it and process it in a way that best suits their users on their platform. And in most circumstances, only where the internal processes dictated by the social platform have been exhausted, or for example, there is a criminal aspect to the issue at hand, will the grievance be taken outside? So for example, contact the police or contacting a lawyer. However, the social platforms normally have processes in place to cater for these circumstances as well. So again, I cannot reiterate this more. When in doubt, always consider the T's and C's. T's and C's for popular platforms are no longer written in hard to read fine print. They are straightforward, they are simple, and they are easy to read, and they clearly set out. Pardon me, I think there might be a dip in our internet. Sorry, there was a bit of load shedding. Let me just continue to share my screen. There we go. Oh, let's try that again. Okay. Pardon for the delay, everyone. I'm just trying to share my screen. There we go. Cool. So to pick up where we left off, as I said, terms and conditions for social media sites are no longer hard to find or hard to understand. They set out clearly your rights as a user, as well as any points in time where the liability of the social platform is limited, especially for platforms where users upload information like YouTube or SoundCloud. They've clearly set out your rights and processes in respect of any issues. Another big aspect about social media is revenge porn. Revenge porn is, as I mentioned a bit earlier, the unlawful sharing of intimate images, films, or media. Revenge porn is a criminal offense under both the Cybercrimes Act as well as the Films and Publications Act. Under the Forms of Publications Act, anyone that is found guilty of perpetrating the offense of distributing revenge porn, where the individual is harmed, but their information or their person is not fully identifiable from the image, will be guilty of an offense and might be subject to a fine of 150,000 rand or to imprisonment for a period not exceeding 2 years, or both a fine and imprisonment. However, where an individual is identifiable from the distribution of the film or picture, or whatever it may be, the fine is increased to 300,000 rand, or then imprisonment not exceeding 4 years, or both imprisonment and a fine. Furthermore, which is very interesting, is under the Forms of Publications Act, it is actually a defense that for someone charged with the crime of distributing revenge porn to prove, and they would have to prove this, that they believe that the sharing of the information was necessary for the purposes of preventing a crime, which is quite interesting if you think about it, but it remains to be seen again how this will be implemented in everyday life and how this will work. And similar to what I mentioned earlier, an internet services provider, again under this crime, under the Forms of Publications Act, will be compelled to provide the Forms of Publications Board or the South African Police Services with the information and identity of the person who published the revenge porn content, which is again very interesting to understand how this will be in practice, considering the implication of it with internet service providers. The Cybercrimes Act also regulates revenge porn, as I said. However, the Cybercrimes Act doesn't institute or doesn't define what a fine will be if you are convicted of distributing revenge porn. And again, it's, as I said, the updates to the Forms of Publications Act have caused a stir and certain conversation as to how it will be implemented, and it will be interesting to see how these two acts will intersect, considering it's a crime under both acts. But there's been lots of comments online from people and other lawyers saying that the Cybercrimes Act might be better fitted to regulate this crime as opposed to the Forms of Publications Act. But again, it's not yet been established in law. There's no case law. There's no precedent on how it will be dealt with, and it will be interesting to see when it does happen, how the courts handle it. Next, posting online. I think this is an important thing, and it might seem very straightforward and common sense, but what I want to hammer home is that with the advent of copy, the most important thing to remember when considering whether to post a picture or video is consent. Consent is so fundamental, and you always need to ask yourself, do you have the person's consent? If someone is in the picture with you, or that it's only of them, do you have their consent? And if not, you cannot post that picture, especially not, even if it's your friend at the braai last week. If they've said no, they've said no. Photographs, especially very clear photographs, are personal information, and that's it identifies someone clearly, and they always have to provide the consent to post it. And if I've not hammered that home enough, what I really want to instill is that what's most important to remember is do not post pictures of anyone's children without that parent's consent. Children and personal information of children is extremely sensitive information, and it cannot and should not ever be distributed without a parent's consent. In the context of schools, this should normally be obtained in the beginning of the year by the school, whether through a form or by accepting the school's privacy policy, etc. But schools also always have to have the parental consent before posting any images of children online. When it comes to your own images and your own content, by all means do so as you wish. But what I want to have and want people to be aware of is that it's always best to avoid filming oneself in compromising positions and have it posted online. Remember, anything that's shared online can be shared again. And it's always best to remember, if you don't want something that you've said or that you've posted or that you've commented coming back to you, then maybe think twice about distributing it or sharing it. Like I said, always consider what you say in a voice note, especially in a group chat. I mean, we all can think back to the incident with the South African golfer, where everybody was privy to his voice note to his girlfriend, where he's talking about his pork and his teddy bear and his special person. If you don't want something like that, you always understand that anything sent electronically is able to be shared repeatedly. If you don't want something to come back to you, think twice before you send it. I know I chatted earlier about things being defamatory and things like that, but in circumstances where it's not defamatory, something can be shared. If you've allowed something to be public information, it's in fact public information, and it can be shared as much or as little as people want. Online shopping and the Consumer Protection Act. So with respect to online shopping, although we've advanced, we've advanced many years and many strides in the realm of e-commerce, especially in South Africa, it's still a bit of a wild territory, with there being lots of scams and lots of uncertainty as to what or which online stores are reputable or not. Although there's no specific, legalities that we can point you out to, what I'd like to do is to offer you some tips, to understand or to check whether an online store is reputable or not. There are the chance, that something is not, but what I want to do is just maybe give you some pointers that at least act as a guide when shopping online. So first and foremost, what I want to say is do your homework. If you're on a website and it seems a bit dodgy, always try and check the T's and C's. T's and C's require a website to list the company name and some bits about the company information. And if it doesn't seem right or doesn't seem like it relates to the brand or the product that you're purchasing, that might be a red flag. Also, always consider a company, a brand, or store's official social media, which will normally have a link to their official website. If the website that you're on is not listed on that brand's page, that might be a big red flag to tell you that things are not so right. Secondly, always make sure that a website or an application uses reputable payment services providers. This is a big thing. Normally, dodgy websites do not have reputable service providers. It might show Visa or MasterCard at the end, but you need to be sure that the payment provider that they're using is reputable. Things like 3D Secure, PayFast, PayFlex, big reputable payment services providers is a good indication that a store is reputable. Also, in terms of the Consumer Protection Act, you need to be provided with a tax invoice after you purchase. If a site's not offering you a tax invoice or has not provided you a valid invoice, or the invoice looks slightly dodgy, there might be an indication that it's not a reputable site and it could be a scam. Always double check invoices for things such as the company's full name, their registered address, contact information, and things such as that. And lastly, always read the reviews. Whether it be through Google, through the website, through other reputable sites such as Hello Peter, for example, always try to read reviews. Users will normally be honest and straightforward about what the product is, the brand, the experiences, and that'll normally be the best indication as to whether something is reputable or not. It's always goes back to word of mouth, and word of mouth normally will be an indication as to whether you should shop online with that brand or company or not. Next, the Consumer Protection Act. This is a question that I've gotten often, and it's something that I really wanted to chat about. We all understand that the Consumer Protection Act exists, and it exists to ensure that us as consumers are afforded a safe and reliable marketplace. But what I really want to emphasize is that the Consumer Protection Act does not always apply. The Consumer Protection Act does not, in fact, apply in circumstances of a private sale. These are sales between everyday people. This could be for a cell phone or a car or anything really that is just not in the ordinary course of someone's business. So, as I said, the CPA applies to suppliers, and that's the term used in the Act, to supply any goods and services in the ordinary course of business. So if a sale is made by someone, say for example me, Every day I'm a lawyer. So if I'm selling something online, that is outside my ordinary course of business, and therefore the Consumer Protection Act does not apply. In the circumstances of a private sale, any dispute between the two parties is handled in terms of our common law. So the advice that I would give if you are going to engage in a private sale is to capture the terms of your sale in an agreement. I know that that seems very standard for me as a lawyer to say that something should be captured in an agreement, but it's true. And the agreement doesn't necessarily have to be drafted by a lawyer. You can have a simple page in which you guys write down the terms of the sale, both of you agree to it, and both of you sign it. As long as it's captured somewhere, it offers you certainty and protection as to the terms of the sale. In circumstances where the CPA does apply, the CPA offers lots of protections to consumers. Without running into too much detail, if you have any questions on it, you can by all means contact us. But one of the things that I want to bring people's attention that the CPA offers is that one of the rights is the return of goods, and goods can be returned under certain circumstances. These include, for example, where you are not offered the right to inspect the goods in advance, or they do not meet certain standards. Another important right that I really want to bring people's attention to is the right to safe and good quality goods. This is an important with respect to things that are bought that show or manifest defects later on, or defects that were not immediately visible when the product was bought. This right under the CPA requires that goods purchased by a consumer should be reasonably suitable for the purpose for which they are intended, that the goods are of good quality and in good working order, that they do not have any defects, and that they will be able to be used and will be durable for a reasonable period considering the purpose of the goods or what they were meant for. Where something does not meet those requirements and is not safe and good quality, a consumer has the right to return within 6 months the goods. And once the consumer has elected to return the goods in terms of the CPA, they will have an option as to whether they want the supplier to either repair or replace the defective good, or where they want to receive a refund. So this right is it's in above with the refunds policy that a supplier might have. It doesn't nullify or take away, but it's in conjunction with any refunds policy that a supplier might have. As suppliers also do have the right to have their own refund policy and decide how they want to implement this. But there are certain requirements. As I said, the product you'll have to show that the product is defective, that defects are present, that these defects were latent, and all those kinds of things. And that brings us to the end. If anyone has any questions, I'll be more than happy to answer. Cool. So I see this question. And how are international cybercrimes dealt with, such as scammers that focus on some people? So, sorry, I read it to myself. The question is, how are international cybercrimes dealt with, such as offshore scammers that focus their efforts on South African people? So, as I said, even the Cybercrimes Act allows our courts to prosecute crimes that have been committed over the internet that have been committed to South Africans. But because the Cybercrimes Act is new and there's no case law yet, we'll have to see exactly how this is implemented. As I said, it's one thing to give the courts jurisdiction to try these kinds of crimes, but before something lands in court, there has to be an investigation. And I think it will be something to be seen how the South African Police Service kind of implements this and investigates these sorts of cyber crimes, because it is obviously difficult to track someone down through the internet. So yeah, it's something that's very novel and very new, and I'm hoping that with the implementation of the Cybercrimes Act that there'll be some sort of headway in this to ensure that South Africans are protected, because this is an issue all across the world. How do you fight a cybercrime? How do you find a person that's hiding away in some remote corner of the earth? So there's no definitive answer, and it will have to be seen how this is implemented with our law. But it's some sort of comfort, it's a slight comfort knowing that it is something that our courts can deal with, but how the police services finds these people and how the case is kind of formulated and developed will remain to be seen as time goes on. But yeah, if there's any other questions, people can just pop it through on the chat function. I'll be happy to answer. Otherwise, you could always contact us at our website if you want to know anything more, if you've had any issues, if something, a cybercrime has happened to you, and we can maybe guide you and assist you. A product that we've also launched is our social media and influencer law. So if you are, your social media is your business and there's something that you operate, we can definitely help you with any agreements that you might need, especially if you are a brand or agency or an influencer yourself. This is definitely something that we can assist with. But yeah, thank you everyone for joining, and I'm so glad you came and listened to my talk. If there's no other questions in the next 2 minutes, then I think we can end off. Just give maybe like 2 minutes, but yeah, thank you everyone for joining. Pop to the next slide. As I mentioned, if you want to contact Legalese, this is our contact information. We're always available at our website or via our telephone lines. And again, yeah, thank you everyone for joining, and I hope everyone has a great day. Thank you so much. Bye everyone.